Judge Smith did bring up a point I want to dig into deeper, though. Instead, Bruen reiterates that the Second Amendment right belongs only to law-abiding citizens. Duarte's Second Amendment challenge to 18 U.S.C. Section 922 G1, as applied to nonviolent offenders, is therefore foreclosed. If someone is convicted of a crime, does that mean they are forever labeled as not a law-abiding citizen? Does a single conviction, even of a nonviolent crime, leave someone with the equivalent of the mark of Cain, forever labeled as a criminal? What about those who fulfill their debt to society? Does completing their sentence fulfill their debt? Are they forever held liable for their transgression of the law? I can see a rationale behind prohibiting those with violent felony convictions, especially multiple such convictions, from possessing firearms. But we still have issues with 922G, because 922G does not ban felons in possession, as many refer to it, but people who have been convicted of crimes punishable by more than a year in jail. I believe there are several states that have misdemeanors which can carry punishments of a year or more in jail. I do not believe the opinion of the court states whether or not Mr. Duarte's conviction were felonies or not, only that he was sentenced to more than a year in prison for each of them. Now, if we can agree that there are crimes and situations where the punishment should include the loss of certain rights, such as the right to the possession of firearms, what is the proper way to go about it? First of all, except for Washington, D.C. and the land purchased from the states, Congress does not have the authority to write general legislation for the nation. Congress does have the authority to regulate interstate and foreign commerce, but the attempt to bootstrap this legislation by claiming to regulate everything that passes through interstate or foreign commerce would be laughable if so many courts didn't follow along. If Congress can claim the power to regulate everything that passes through commerce, then they can regulate just about everything in our lives. This reminds me of the warning James Madison gave about the General Welfare Clause. In short, everything from the highest object of state legislation down to the most minute object of police would be thrown under the power of Congress, for every object I have mentioned would admit to the application of money and might be called, if Congress pleased, provision for the general welfare. If everything that passes through interstate or foreign commerce can be regulated by Congress, then everything you buy can be regulated through commerce. Even worse, since 922G doesn't simply claim to regulate commerce, but the rights of people to possess a product that passed through interstate commerce, at some point, it is pretty much everything we purchase in this day and age. So Congress does not have the authority to pass general legislation outside of legitimate federal land. Neither does it have the authority to regulate products, only interstate and foreign commerce. So it appears 922G is unconstitutional and therefore invalid. But there are more questions we should be asking. For example, when someone is sentenced, is that the limit of their punishment? Is it due process for Congress to impose a penalty via legislation beyond what is imposed by a judge? How can a law passed by Congress consider the circumstances in a specific case? When should someone be deprived of their rights as punishment for a crime? Should someone be shown to be a danger to society before government deprives them of their rights? Is the punishment of a permanent loss of rights cruel or unusual?